the Attorney General Barr found irregularities in the case of Michael Flynn and the way he was tried, the way he was framed. That's a word that sounds rough, but it's a word that have to be used in this case, in which you have elements who are not based on anything that having to do with the crime itself, if any, he had committed. They try to destroy somebody in order to get to a third person or for an ulterior purpose. But let's see what is amicus brief. An amicus brief is a legal document that can be filed in an appellate court case by people who are not litigants in the case, who have an interest in the case or subject matter, have an interest in the case. So, what people have an interest in the case of General Flynn? The people who wants to keep him in jail and the people who don't want to keep him in jail. So it depends who calls who's to play what, where, and when. So nearly anyone who is interested in a case can file an amicus brief or amicus brief of Amigos de la Corte. Es we can say, una persona que no tiene nada que ver con el caso, and you call them in to join in the fight, either to clarify or to have a fresh look at what you are faced with. In the case of the court, it has to be in an appellate stage of the case. The case is already tried. There's already a decision in the case, and now we are back in appeal because the attorney who represents Michael Flynn, her name is Sydney, I don't remember the last name. The attorney who represents Michael Flynn requests for the case. In other words, she presented the case in a matter that shows documents that were not presented, which will be exculpatory if they were presented to the judge. There were things that had to happen outside the court to present to the court, and Judge Sullivan decided that, in a nutshell, he wasn't going to hear something, and now he decided he wants to hear something from outside sources. But let's continue reading. We back. Nearly anyone who is interested in the case can file an amicus brief as long as they meet a few basic requirements. I don't know. We're not going to go in deep detail of the requirements, but think about this. When you, in this case, the court, we don't know if it's the court, the judge, who, but he's the one who's talking about the select, at least, it's talking about an amicus brief. But how much will anybody expect to pay? Is the attorney who's going to write the amicus brief? Is it an organization? Is the owner of Tesla? Who? But probably this will cost between $300 and $700 an hour. We are now seeing, depending on whom is hired, it could be even a doctor, okay, a forensic. It could be Comey if they want. I don't know. So this could take between 40 and 80 hours, depending on how complex is the case. So put it, I don't know, 12,000, 24,000, whatever, because money is not an issue since the judge is not going to pay, right? Who's going to pay? Probably you or me. Amicus briefs are legal documents filed with the appellate court cases by non-litigants with a strong interest in the subject matter. The briefs advise the court of relevant additional information or arguments that the court might wish to consider. The situation most often noticed in the press is when an advocacy group files a brief in a case before an appellate court in which is not a litigant. More so you can see that when there is an amicus brief, when there is something related to immigration, and there is a group of immigrant activists one of those that live off the immigrants, because if there were no immigrants, those activists will have no food. So they need the immigrants to be in order to make money. But it's still, those are the ones that come and they file the amicus brief, and then it's a big commotion about that, because everybody wants to hear what they have to say, and everybody speaks so clearly and so whatever, but it doesn't matter. Well, all right. Appellate cases are normally limited to the factual records and arguments coming from the lower court case under appeal. Attorneys focus on the facts and arguments most favorably to their client. All right? Where a case may have broader implications, an amicus brief are a way to articulate those concerns, so that the possible broad legal and public policy ramifications of the court's anticipated decision will not depend solely on the positions and arguments advanced by the parties directly involved in the case. So right now, we are talking about the parties involved in the case. Who are they? The people who want General Flynn down and the people who want General Flynn out. Anyhow, that judge made a decision saying that, remember when he said, Judge Sullivan, he said, I don't know what he said, you are an embarrassment for the country. Told that to General Flynn. So we're talking about somebody that's supposed to be neutral, one way or the other. He doesn't supposed to say, either look with disdain to General Flynn or say anything, because he's a neutral party who's going to listen to both sides. Okay, we're going up to that point. All right? Now, Sullivan, let's find out who Sullivan is. Sullivan was, an attorney in District of Columbia. He has a law firm or was in private practice. Then he was appointed to some judgeship by Reagan. All right? That's why we were talking about it doesn't matter who put you where. If you are going to do your job ethically, it doesn't matter who appointed you. You don't owe favors to anyone. But Reagan appointed him back in the, the 1900s. Okay? Then Bush moved him up to the other level where he's supposed to be. Right? Clinton appointed him to the Supreme Court of District of Columbia. Bill Clinton. Listen to the cases that had been the most, because let's be honest, you and I didn't know a rat ass who Judge Sullivan was until now. We didn't know who he was. We regularly, routinely, we are not going to know who the judges are, and we really don't care. We just care for them to do the right thing when it's the time that we have to be in front of them or whatever. But these are the cases more notably involving Sullivan that he has presided. Okay, he has presided over a number of habeas corpus. Habeas corpus on those petitions submitted when somebody is detained, and then you think that the person is being detained and they shouldn't be detained, and then you submit a habeas corpus. Is some other animal that, it's difficult. No, I don't even understand it. But those habeas corpus petitions, it were submitted on behalf of the men that were detained in Guantanamo Bay. After the 9/11 attacks. So Judge Sullivan presided over those cases, okay? He also presided over in 2008 over the case of Senator Ted Stevens. That senator was on the bench. It was like el tipo más viejo que estaba in the bench. He was there since 1967. Until, 2009 maybe. So Senator Ted Stevens, he was convicted of 7 felony ethics violations, right? During the trial, the Judge Sullivan, refused requests by the defense for a mistrial to be declared after information was revealed that the prosecution had withheld exculpatory Brady material. This Brady material, they give names to these things after decisions by the parties at that time. So maybe it's Brady versus whomever. So that decision, it takes precedent, and then every time you're going to talk about or bring a subject matter jurisdiction, I just dropped that there, sounds good, subject matter jurisdiction. But you just say Brady materials, whatever. But the Brady materials was, in that case, it was exculpatory evidence that could shed light to the innocence, or maybe the culpability, well, in this case, the innocence of the guy, and the prosecutors intentionally withheld that in order to, bring the guy down and mandarlo a que se pudra para la cárcel. Pero bueno, 8 days after the guilty verdict, Stevens narrowly lost his re-election bid. You understand that? This was done in order for this Stephen guy to not be able to stand the election. So it was kind of, you could say, has a political color on it. And Sullivan was involved. All right. So, but yeah, Stevens narrowly lost his re-election bid, right? As more evidence of prosecutorial misconduct became known in early 2019, Judge Sullivan held 4 prosecutors in civil contempt of court. There is more. On April 1st, 2009, following a Justice Department probe that found additional evidence of prosecutorial misconduct. Sounds familiar? The Department of Justice recommended that Stevens' convictions be dismissed. And you're going to tell me back in 2009, the Department of Justice was led by Barr? No, it was not. All right. So now, on April 7, 2009, Sullivan set aside the conviction and appointed a lawyer to investigate. Look how much time had to pass, right? So, appointed a lawyer to investigate the prosecution team for criminal contempt. Subsequently, one of the prosecutors held in contempt killed himself. We don't know if Sullivan is a little traumatized for that. He doesn't want to go through it again. But certainly, I wouldn't want General Flynn, the one killing himself, because he thinks that the whole world is out to get him. All right? Justice had to be served everywhere. Okay. So ultimately, I guess Sullivan fell back. Sullivan dismissed the civil contempt charges, and no additional charges were brought against the prosecutor. Period. So that prosecutor killing himself took one for the team, because that forced the hand of Sullivan to drop the charges against all the prosecutors. Oh, sorry, my mistake. I'm sorry, I shouldn't have done that. I should have left it like that. You would be alive now. Okay. In 2014, Sullivan was presiding over a case, Judicial Watch versus the IRS, relating to an ongoing investigation into the 2013 IRS controversy. You remember in 2013, a bunch of Republicans where, they sent the IRS on them to investigate them because they, I don't know. Pero bueno. There was an attempt to determine where the deleted emails of former, does not know about the emails being deleted, of former IRS employee Lois Lerner had gone. I don't know who she is, but somebody will. What damage to her computer hard drive occurred, and what steps the IRS have taken to recover the information contained in the emails and the hard drive. Ooh, bleach bit again? Oh no, again now. In 2015, Sullivan presided over FOIA, Freedom of Information Act lawsuit involving the matter of Hillary Clinton's private email use while Secretary of State. According to the American Civil Liberties Union, it's another case, A woman and her child fled domestic abuse in El Salvador to seek asylum in the U.S. However, the mother was removed from her detention facility and likely put on a plane on August 9, 2018, despite Justice Department promises that she and others will not be deported, before the judge could rule on the case. Sullivan demanded, "Turn the plane around!" You remember that? I don't. He threatened to hold those responsible for removal in contempt of court, starting with the Attorney General Jeff Sessions. Remember? If the situation was not rectified, a Department of Homeland Security official stated, "We are complying with the court's request. The plaintiff will not disembark and will be promptly returned to the United States," whatever. So you see where are we coming? A little bit of his history and this flamante judge, Sullivan. So all of this has been put out in an attempt to understand where we are now. We are an amicus brief that is being requested by this judge. He wants people from the outside to come and say their say-so in the case before he can drop the charges that rightfully so have to be dropped because of blatant irregularities and violations. Therefore, we can. Oh wait, I have to go walk the dog. Walk the dog, right? For real. So therefore, people, right now there is enough information out there for us to determine at what point the justice is just left by the eye of the beholder. We are going to make sure that we have the complete entereza to decir, you know, Judge, if you want to say with all disrespect, you can throw out there, but the buck stops here. If you see that happening to General Flynn, 2 days later it's going to happen to you, and you are no general, and you are no Flynn, and you are not connected. So therefore, you're going down, and nobody's going to say anything. Because why should we? If the judge said so, I guess the judge is the expert, so the judge cannot bring any outside ideals of conception or preconception. So they're gonna allow you to go down with nobody even saying zip to defend you when they see fit. So do the good that is there to be done when the opportunity presents itself. This is the end of the work on this file, end of the tape. Okay, now I can go. Papa wants to pick me. Wants me to pick him up. It's you know, that's what I live off of. ¿Cómo?